Okay, everyone. Several new filings in Don Lemon's criminal case this week. The filings make clear that the defense is in disarray, and, in my view, some of the defendants and their attorneys may be starting to realize that they're in over their heads. Now, last week, some of the defense attorneys alleged that the government's discovery material had too many redactions and complained that they had the right to information about non testifying witnesses. Now, Rule 16 governs discovery in criminal cases, and it's clear that non testifying witness information need not be disclosed as a general matter. Only Brady and Giglio material and material that the government intends to use in its case in chief at trial, such as information on testifying witnesses, must be disclosed under Rule 16. Further, Rule 16 doesn't prevent the defense from doing its own investigation and finding out that information on its own. We're just talking about the discovery process here, not the process of investigating claims and defenses generally, which should go beyond the categories of material discoverable under Rule 16. The defense, for example, is only limited from further investigating the case on its own by the conditions of release imposed by the court. All defendants have to stay away from City's Church, that is to say. But beyond that, they can go anywhere and investigate. Now, the glitch with that, of course, is the fact that they may have to hand over the product of their investigations to the government if the government requests that information under Rule 16. Now, we also found out in the filings this week that anti-ICE activists continue to harass and dox churchgoers at City's Church. Apparently, there's a gauntlet in front of the church every week. Don Lemon's not out there every week because of the stay-away order, but it seems that a new group of activists have taken up the cause. So, if I had to guess, the new group of activists who are continuing to harass and dox churchgoers every week just for attending church will be arrested sometime in the future as part of a separate indictment. Just my guess, based on the fact that the government mentioned in one of its filings this week that the harassment and doxing by new agitators continues. A big clue there. So, here's an example of discovery material that the government produced last week. Heavily redacted, the government's new filing this week states that the possibility of witness tampering, which could include witness intimidation, and the possibility of further doxing of federal agents justifies continuing to redact the names and personally identifiable information of victims, witnesses, and federal agents. With the implication being, now, even if that material is within Rule 16, although we don't know for a fact that that material is within Rule 16, the government hasn't said that it is. Now, the court has decided to view the defense request for a status conference as an accusation by the defense that the government is violating Rule 16, in so many words. But in my view, the defense needs to follow the process and prepare and file a motion to compel discovery. The defense needs to ask for the discovery material that it is genuinely entitled to under Rule 16. And that's what the court said in its discovery order this week. The court is requiring the government to unredact information if it's within Rule 16. Now, that's a big if. Now, with all of that being said, the government did make a play for broader redactions pursuant to the Crime Victims Reform Act, which imposes mandatory duties on the government and the court to safeguard the rights of victims to be reasonably protected from the accused. Now, the government said this week, and I quote, "It would be irresponsible for the government to ignore the facts of this case and the aggressive tactics of modern protesters and simply trust that the defendants and their associates will honor the basic norms of decency and civility that they violated on January 18th, 2026. The Crime Victims Reform Act provides victims with a remedy if the court and the government are forced to disclose victim information that violates the CVRA. So that sets up a remedy for victims if their information is disclosed. For example, pursuant to Rule 16, under Brady, Giglio, etc., or if it's disclosed inadvertently. Now, I'm aware that there's already a law firm representing the church on the issue of civil rights because, needless to say, churchgoers who are walking through a gauntlet every week just to attend church, of course their civil rights are being violated. Now, there are plenty of lawyers in Minnesota who can file CVRA motions for individual churchgoers if their information is exposed under Rule 16, and potentially those cases could be done pro bono. Now, attorney fees are recoverable after the fact if they prevail against the government because those motions under CVRA are filed against the government's disclosure of the victim's personal information, even when the government is forced to do so by the court under Rule 16. Now, if a CVRA motion is filed, the government might even decline to defend in a given case. In any event, back to the defendants' misconduct. Now, half of them, there's 38 defendants, but half of them still haven't returned their signed certifications, which indicate that their legal defense teams understand and submit that they are not permitted to use discovery material for any purpose other than the current case and any appeal. That doesn't bode well. There's a huge risk of doxing if the defense team still haven't returned the signed certifications. I am shocked by the behavior of these defendants in that they're continuing to harass churchgoers. In my view, it's looking like prison time. Now, I believed it would be prison time for the two leaders and the hype man, but it probably will go beyond that. Thanks for watching, and if you enjoyed this video, leave a like and don't forget to subscribe.